all of the exhibits yesterday afternoon in your absence. And so I will read off the numbers. You will receive all of the exhibits back in the jury deliberating room, except initially for the baseball bat and the skulls. They will be retained here in the courtroom. If in deliberations you wish to examine either the baseball bat or the skulls, you'll need to request it. When you request it, the deputy will bring it back, and we'll also have gloves for all of you to put on and to the extent you wish to handle it. And those items will not be sent back initially. Now also, obviously, there were some tapes and videos that were presented to you during the course of the trial. They will all be sent back to you as well. To the extent you wish to review any of them, we'll provide an apparatus to you to do so. And obviously, watch it again or listen to it again if you wish. Also, with respect to your transcripts, to the extent you still have them, we're not going to have you bring them back. We'll have you leave them on your seats. And then if you wish to listen to any of the tapes, either audio or video audio, then we'll give you the transcript back, and the transcript that has your juror number on it will be provided back to you if you wish. So that's how we'll do. All right, so as I mentioned yesterday, the lawyers and I did go over the exhibits, and the following exhibits have been entered into evidence to be made available to you during your deliberations. We have Peoples 1 through 17, Peoples 18 through 28, Peoples 30, Peoples 38 through 42, Peoples 43 through 46, Peoples 48 through 52, Peoples 54 through 59, Peoples 61 through 68, Peoples 70 through 74, Peoples 79 and 80, Peoples 82 and 83, Peoples 85 through 89, Peoples 92, Peoples 95 through 105, Peoples 109, Peoples 111, Peoples 113 through 117, Peoples 119 through 125, Peoples 128 and 129, Peoples 131 through 136, Peoples 138 through 141, Peoples 142 through 150, Peoples 154, 155, 156A, 157, 158, 158A, 159A, 159B, 159C, 160, 161, 161A, Peoples 163 through 165, Peoples 167 through 169, 171 and 172, Peoples 174 and 175, Peoples 179 and 180A and 181A, Peoples 183 through 188, Peoples 189, Peoples 202 through 204, Peoples 208 through 211, Peoples 213, 215 through 217, 218 through 226, Peoples 228 through 234, Peoples 237, and finally Peoples 240, 241, 243, 45. Those are the exhibits that have been admitted. Also, Defense A was admitted as well. So all of those will be made available to you either by request or will be initially sent back to you. All right, now, ladies and gentlemen, it's that part of the trial where the court has to read to you what we call jury instructions, which is the law that applies in the case. As I'm reading this to you, please do not feel compelled to have to feverishly write down what I'm saying. We'll give you a copy of everything that is being said to you. If you wish additional copies, we will provide them to you also in deliberations. However, as I'm reading through the instructions, if something that I say is of note to you or of value to you, if you want to jot down, you may want to do that in your notes. When I'm done reading just about all of the instructions except for the concluding instructions, I will stop and then I'll turn the floor over to the lawyers for their closing arguments. Now you're going to hear 3 closing arguments today. Why 3? Well, you'll hear first from the prosecution, and my understanding is Mr. Kurz giving the opening argument. Then you'll hear from the defense, Mr. Jensen. And then because the prosecution carries the burden of proof, they will get a rebuttal closing argument. My understanding is that'll be Mr. Beecham doing that. Now remember again, the closing arguments are not evidence. The only thing that's evidence in the trial were the answers given by the witnesses from the witness stand, the exhibits that have been admitted into evidence, and the stipulations that we will have as well. The lawyers' closing arguments are not evidence. Now again, that is not to imply that they are not important. In their closing arguments, the lawyers will utilize the law that the court will read to you, along with the facts as they see them, in an attempt to persuade you to one side or the other. They're very helpful to you in your deliberations. And remember, they are not evidence. Now, I tell you that for 2 reasons. First, if a lawyer were to misstate something, and believe me when I say none of these lawyers would intentionally misstate anything, but their view may be a little bit different than the other side's view, or maybe even your view. Irrespective of that, and if there is an objection, again, ultimately, you are the purveyors of the facts. You determine what the facts are in the case. And so ultimately, it's up to you as to what happened. The second reason that I say that is because it is not evidence. You cannot get feedback of a lawyer's closing argument. So as points are raised by them that you think are worthy of discussing with your fellow jurors, you may want to jot it down in your notes, because you will not be able to ask the court reporter to read back to you a second time what was said. All right, so with all of that said, we'll go ahead and begin the instructions. Members of the jury, I will now instruct you on the law that applies in this case. The instructions that you receive may be printed, typed, or written by hand. Certain sections may have been crossed out or added. Do not disregard any deleted sections and do not try to guess what they might have been. Only consider the final version of the instructions in your deliberations. You must decide what the facts are. It is up to all of you and you alone to decide what happened, based only on the evidence that was presented to you in this trial. Not let bias, sympathy, prejudice, or public opinion influence your decision. Bias includes, but is not limited to, bias for or against the witnesses, attorneys, defendant, or alleged victims, based on disability, gender, nationality, national origin, race or ethnicity, religion, gender identity, sexual orientation, age, or socioeconomic status. You must follow the law as I explain it to you, even if you disagree with it. Believe the attorney's comments on the law conflict with my instructions. You must follow my instructions. Pay careful attention to all of these instructions and consider them together. If I repeat any instruction or idea, do not conclude that it is more important than any other instruction or idea just because I repeated it. Some words or phrases used during this trial have legal meanings that are different from their meanings in everyday use. These words and phrases will be specifically defined in these instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in these instructions are to be applied using their ordinary everyday meanings. Some of these instructions may not apply, depending on your findings about the facts of the case. Do not assume just because I give a particular instruction that I am suggesting anything about the facts. After you've decided what the facts are, follow the instructions that do apply to the facts as you find them. Do not use the internet or a dictionary in any way in connection with this case, either on your own or as a group. Do not investigate the facts of the law or do any research regarding this case, either on your own or as a group. Do not conduct any tests or experiments or visit the scene of any event involved in the case. Happen to pass by the scene, do not stop to investigate. You have been given notebooks and may have taken notes during the trial. You may use your notes during your deliberations. Your notes are for your own individual use to help you remember what happened during the trial. Please keep in mind that your notes may be inaccurate or incomplete. If there is a disagreement about the testimony and stipulations of trial, you may ask that the court reporter's record be read to you. It is the record that must guide your deliberations, not your notes. You must accept the court reporter's record as accurate. Please do not remove your notebooks from the jury room. At the end of the trial, your notes will be collected and destroyed. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. It must not be biased against the defendant just because he has been arrested, charged with a crime, brought to trial. The defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Whenever I tell you that people must prove something, I mean they must prove it beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt, because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all of the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he is entitled to an acquittal. You must find him not guilty. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, anything else that I told you to consider as evidence. Nothing that the attorneys say is evidence. Their opening statements and closing arguments, the attorneys discuss the case. Their remarks are not evidence. Their questions were not evidence. Only the witnesses' answers were evidence. The attorney's questions are significant only if it helps you to understand the witness's answers. Do not assume that something is true just because one of the attorneys may have asked a question suggested it was true. During the trial, the attorneys may have objected to questions or moved to strike answers that were given by the witnesses. I ruled on the objections according to the law. If I sustained an objection, you must ignore the question. The witness was not permitted to answer. Do not guess what the answer might have been or why I ruled as I did. If I order testimony stricken from the record, you must disregard it and not consider that testimony for any purpose. You must disregard anything you saw or heard when the court was not in session, even if it was done or said by one of the parties or witnesses. During the trial, you were told the people and the defense agreed or stipulated to certain facts. That means that they both accept those facts as true. Because there is no dispute about those facts, you must also accept them as true. The court reporter has made a record of everything that was said during the trial. If you decide that it is necessary, you may ask that the court reporter's record be read to you. You must accept the court reporter's record as accurate. Facts may be proved by direct or circumstantial evidence or by a combination of both. Direct evidence can prove a fact by itself. For example, if a witness testifies he saw it raining outside before he came into the courthouse, that testimony is direct evidence that it was raining. Substantial evidence also may be called indirect evidence. Substantial evidence does not directly prove the fact to be decided. It is evidence of another fact or group of facts in which you may logically and reasonably conclude the truth of that fact in question. For example, if a witness testifies that he saw someone come inside wearing a raincoat covered with drops of water, that testimony is circumstantial evidence, as it may support a conclusion that it was raining outside. Both direct and circumstantial evidence are acceptable types of evidence to disprove the elements of a charge, including intent and mental state, and acts necessary to a conviction. Neither is necessarily more reliable than the other. Neither is entitled to any greater weight than the other. You must decide whether a fact and issue has been proved based upon all the evidence. Before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to find the defendant guilty, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant is guilty. If you can draw two or more reasonable conclusions from the circumstantial evidence, one of those reasonable conclusions points to innocence, another to guilt. You must accept the one that points to innocence. However, when considering circumstantial evidence, must accept only reasonable conclusions, reject any that are unreasonable. You alone must judge the credibility or believability of the witnesses. Deciding whether testimony is true and accurate, use your common sense and experience. Judge the testimony of each witness by the same standards, setting aside any bias or prejudice you may have. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. Among the factors that you may consider are: how well did the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them correctly? Was the witness's testimony influenced by a factor such as bias or prejudice, personal relationship with someone involved in the case, or a personal interest in how the case is decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all of the other evidence in the case? Could other evidence prove or disprove any fact about which the witness testified? Do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the same event, yet see or hear it differently. If you do not believe a witness's testimony that he or she no longer remembers something, that testimony is inconsistent with the witness's earlier statement on that subject. If you decide that a witness deliberately lied about something significant in this case, you should consider not believing anything that witness says. Or, if you think the witness lied about some things but told the truth about others, may simply accept the part that you think is true and ignore the rest. Neither side is required to call all witnesses who may have information about the case or to produce all physical evidence that might be relevant. The testimony of only one witness can prove any fact. Before you conclude that the testimony of one witness proves a fact, you should carefully review all of the evidence. If you determine there is a conflict in the evidence, you must decide what evidence, if any, to believe. Not simply count the number of witnesses who agree or disagree on a point and accept the testimony of the greater number of witnesses. On the other hand, do not disregard the testimony of any witness without a reason or because of a prejudice or a desire to favor one side over the other. What is important is whether the testimony or any other evidence convinces you, not just the number of witnesses who testified about a certain point. During the trial, certain evidence was admitted for a limited purpose. You may consider that evidence only for that purpose and for no other. You have heard evidence of statements that witnesses made before the trial. You decide that the witness made those statements. You may use those statements in two ways. One, to evaluate whether the witness's testimony in court is believable, and two, as evidence that the information in those earlier statements is true. Witnesses were allowed to testify as experts and to give opinions. You must consider the opinions, but you are not required to accept them as true or correct. The meaning and importance of any opinion are for you to decide. Evaluating the believability of an expert witness, follow the instructions about the believability of witnesses generally. In addition, consider the expert's knowledge, skill, experience, training, and education, the reasons the expert gave for any opinion, and the facts or information on which the expert relied in reaching that opinion. You must decide whether information on which the expert relied was true and accurate. You may disregard any opinion that you find unbelievable, unreasonable, or unsupported by the evidence. An expert witness may be asked a hypothetical question. A hypothetical question asks the witness to assume certain facts are true, to give an opinion based on the assumed facts. It's up to you to decide whether an assumed fact has been proved. If you conclude that an assumed fact is not true, consider the effect of the expert's reliance on that fact in evaluating the expert's opinion. Witnesses who were not testifying as an expert gave their opinions during the trial. You may, but are not required to, accept those opinions as true or correct. You may give the opinions whatever weight you think appropriate. Consider the extent of the witness's opportunity, see the matters on which his or her opinion is based, the reasons the witness gave for any opinion, and the facts or information on which the witness relied in forming that opinion. You must decide whether information on which the witness relied was true and accurate. You may disregard all or any part of an opinion that you find unbelievable, unreasonable, or unsupported by the evidence. A defendant has an absolute constitutional right not to testify. He or she may rely on the state of the evidence and argue that the people have failed to prove the charges beyond a reasonable doubt. Do not consider for any reason at all the fact that the defendant did not testify. Do not discuss that fact in your deliberations or let it influence your decision in any way. You have heard evidence that the defendant made an oral and written statement before the trial. You must decide whether the defendant made any of these statements, in whole or in part. If you decide that the defendant made such statements, consider the statements along with all the other evidence in reaching your verdict. It is up to you to decide how much importance to give to such statements. Consider with caution any statement made by the defendant tending to show his guilt, unless the statement was written or otherwise reported. The defendant may not be convicted of any crime based on his out-of-court statements alone. You may rely on the defendant's out-of-court statements to convict him, only if you first conclude that other evidence shows that the charged crime or a lesser crime was committed. That other evidence may be slight and need only be enough to support a reasonable inference that a crime was committed. This requirement of other evidence does not apply to proving the identity of the person who committed the crime and the degree of the crime. If other evidence shows that a charged crime or a lesser crime was committed, the identity of the person who committed it and the degree of the crime may be proved by the defendant's statements alone. You may not convict the defendant unless the people have proved his guilt beyond a reasonable doubt. If the defendant made a false or misleading statement before the trial relating to the charged crimes, knowing that the statement was false or intending to mislead, that conduct may show he was aware of his guilt of the crimes, and you may consider it in determining his guilt. If you conclude that the defendant made the statement, it is up to you to decide its meaning and importance. However, evidence that the defendant made such a statement cannot prove guilt by itself. People are not required to prove that the defendant had a motive to commit any of the crimes charged. In reaching your verdict, you may, however, consider whether the defendant had a motive. Having a motive may be a factor tending to show the defendant is guilty. Not having a motive may be a factor tending to show the defendant is not guilty. If the defendant tried to hide or discourage someone evidence, that conduct may show that he was aware of his guilt. If you conclude that the defendant made such an attempt, it is up to you to decide its meaning and importance. However, evidence of such an attempt cannot prove guilt by itself. The defendant is charged in count 1, 2, and 3 with murder in violation of Penal Code Section 187. To prove the defendant is guilty of this crime, people must prove the following elements. 1. The defendant committed an act that caused the death of another person. And 2. When the defendant acted, he had a state of mind called malice aforethought. There are two kinds of malice aforethought: express malice and implied malice. Proof of either is sufficient to establish the state of mind required for murder. The defendant acted with express malice if he unlawfully intended to kill. The defendant acted with implied malice if the following elements are met. 1. He intentionally committed an act. 2. The natural and probable consequences of the act were dangerous to human life. 3. At the time he acted, he knew his act was dangerous to human life. And 4. He deliberately acted with conscious disregard for human life. Malice aforethought does not require hatred or ill will toward the victim. It is a mental state that must be formed before the act that causes the death that is committed. It does not require deliberation or the passage of any particular period of time. An act causes death if the death is the direct, natural, and probable consequence of the act, and the death would not have happened without the act. A natural and probable consequence is one that a reasonable person would know is likely to happen if nothing unusual intervenes. In deciding whether a consequence is natural and probable, consider all of the circumstances established by the evidence. If you decide that the defendant committed murder, it is murder of the second degree, unless the people have proved beyond a reasonable doubt that it is murder of the first degree, as defined in Calcrim number 521. The defendant is guilty of first-degree murder if the people have proved that he acted willfully, deliberately, and with premeditation. The defendant acted willfully if he intended to kill. The defendant acted deliberately if he carefully weighed the considerations for and against his choice, and knowing the consequences, decided to kill. The defendant acted with premeditation if he decided to kill before completing the acts that caused the death. The length of time the person spends considering whether to kill does not alone determine whether the killing is deliberate and premeditated. The amount of time required for deliberation and premeditation may vary from person to person and according to the circumstances. A decision to kill made rashly, impulsively, or without careful consideration is not deliberate and premeditated. On the other hand, a cold, calculated decision to kill can be reached quickly. The test is the extent of the reflection, not the length of time. The people have the burden of proving beyond a reasonable doubt that the killing was first-degree murder rather than a lesser crime. If the people have not met this burden, you must find the defendant not guilty of first-degree murder, and the murder would be murder of the second degree. For each count charging murder, you will be given verdict forms for guilty and not guilty of first-degree murder and second-degree murder. You may consider these two different kinds of homicide in whatever order you wish, but I can accept a verdict of guilty or not guilty of second-degree murder only if all of you have first found the defendant not guilty of first-degree murder. As with all the charges in this case, to return a verdict of guilty or not guilty on a count, all of you must agree to that decision. All of these directions before you give me any completed and signed final verdict forms. Return the unused verdict forms to me unsigned. If all of you agree that the people have proved beyond a reasonable doubt that the defendant is guilty of first-degree murder, complete and sign that verdict form. Not complete or sign any other verdict form for that count. If all of you cannot agree whether the defendant is guilty of first-degree murder, inform me that you cannot reach an agreement and do not complete or sign any other verdict forms for that count. If all of you agree that the defendant is not guilty of first-degree murder, but also agree that the defendant is guilty of second-degree murder, complete and sign the form for not guilty of first-degree murder and the form for guilty of second-degree murder. Do not complete or sign any other verdict form for that count. If all of you agree that the defendant is not guilty of first-degree murder, but cannot agree whether the defendant is guilty of second-degree murder, complete and sign the form for not guilty of first-degree murder and inform me that you cannot reach further agreement. Do not complete or sign any other verdict forms for that count. If you find the defendant guilty of the crime of first-degree murder, charged in counts 1, 2, and or 3, or the lesser crime of second-degree murder, you must then decide whether for each crime the people have proved the additional allegation that the defendant personally used a deadly or dangerous weapon during the commission of that crime. You must decide whether the people have proved this allegation for each crime and return a separate finding for each crime. A deadly or dangerous weapon is any object, instrument, or weapon that is inherently deadly or dangerous, or one that is used in such a way that it is capable of causing and likely to cause death or great bodily injury. Great bodily injury means significant or substantial physical injury. It is an injury that is greater than minor or moderate harm. Someone personally uses a deadly or dangerous weapon if he or she intentionally hits someone with the weapon. People have the burden of proving each allegation beyond a reasonable doubt. People have not met this burden. You must find that this allegation has not been proved. If you find the defendant guilty of first-degree murder, you must also decide whether the people have proved that the special circumstance is true. The people have the burden of proving a special circumstance beyond a reasonable doubt. People have not met this burden. You must find the special circumstance has not been proved. In order for you to return a finding that a special circumstance is or is not true, all 12 of you must agree. Defendant is charged with a special circumstance, having been convicted of more than one murder in this case, violation of Penal Code Section 190.2, Subdivision A, Subsection 3. To prove this special circumstance is true, people must prove the following elements. 1. Defendant has been convicted of at least one charge of first-degree murder in this case. And 2. The defendant has also been convicted of at least one additional charge of either first or second-degree murder in this case. Before you may rely on circumstantial evidence to conclude that a special circumstance allegation is true, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to find that a special circumstance allegation is true, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the special circumstance allegation is true. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions supports a finding that the special circumstance allegation is true, and another reasonable conclusion supports a finding that it is not true, you must conclude that the allegation was not proved by the circumstantial evidence. However, when considering circumstantial evidence, you must accept only reasonable conclusions, reject any that are unreasonable. In your deliberations, you may not consider or discuss penalty or punishment in any way, deciding whether a special circumstance or any other charge has been proved. The defendant is charged in count 4 with evading a police officer with wanton disregard for safety, violation of Vehicle Code Section 2800.2. Prove the defendant is guilty of this crime, people must prove the following elements. 1. A peace officer driving a motor vehicle was pursuing the defendant. 2. Defendant, who was also driving a motor vehicle, willfully fled from or tried to elude the officer, intending to evade the officer. 3. During the pursuit, the defendant drove with willful or wanton disregard for the safety of persons or property. And 4. All of the following are true. A. There was at least one lighted red lamp visible from the front of the peace officer's vehicle. B. Defendant either saw or reasonably should have seen the lamp. C. The peace officer's vehicle was sounding a siren as reasonably necessary. E. The peace officer's vehicle was distinctively marked. And E. The peace officer was wearing a distinctive uniform. A person employed as a police officer by the Corona Police Department is a peace officer. Someone commits an act willfully when he or she does it willingly or on purpose. It is not required that he or she intend to break the law or someone else to gain any advantage. A person acts with wanton disregard for safety when he or she is aware that his or her actions present a substantial and unjustifiable risk of harm, and he or she intentionally ignores that risk. That person does not, however, have to intend to cause damage. Driving with willful or wanton disregard for the safety of persons or property includes, but is not limited to, causing damage to property while driving, or committing 3 or more violations that are each assigned a specific traffic violation point. Speeding, not stopping at a stop sign, and not stopping at a red light are each assigned a traffic violation point. A vehicle is distinctively marked if it has features that are reasonably noticeable to other drivers, including a red lamp, siren, and at least one other feature that makes it look different from vehicles that are not used for law enforcement purposes. A distinctive uniform means clothing adopted by a law enforcement agency to identify or distinguish members of its force. The uniform does not have to be complete or of any particular level of formality. However, a badge without more is not enough. The defendant is charged in count 5 with trying to prevent or deter an executive officer from performing that officer's duty in violation of Penal Code Section 69. To prove the defendant is guilty of this crime, people must prove the following elements. 1. Defendant willfully and unlawfully used violence to try to prevent or deter an executive officer from performing that officer's lawful duty. And 2. When the defendant acted, he intended to prevent or deter the executive officer from performing the officer's lawful duty. Someone commits an act willfully when he or she does it willingly or on purpose. An executive officer is a government official who may use his or her own discretion in performing his or her job duties. A corona police officer is an executive officer. The executive officer does not need to be performing his or her job duties at the time the threat is communicated. A threat may be oral or written and may be implied by a pattern of conduct or a combination of statements and conduct. A peace officer is not lawfully performing his or her duties if he or she is using unreasonable or excessive force in his or her duties. Instruction 2670 explains when force is unreasonable or excessive. People have the burden of proving beyond a reasonable doubt that the Corona police officers, Marquez and Jeans, and Canine Dex, was lawfully performing their duties as a peace officer. If the people have not met this burden, you must find the defendant not guilty of preventing a peace officer from performing their duties by use of violence charged in count 5 and count 6. A peace officer is not lawfully performing his or her duties. He or she is using unreasonable or excessive force when making or attempting to make an otherwise lawful arrest or detention. Special rules control the use of force. A peace officer may use reasonable force to arrest or detain someone, prevent escape, or to overcome resistance, or in self-defense. If a person knows or reasonably should know that a peace officer is arresting or detaining him or her, the person must not use force or any weapon to resist an officer's use of reasonable force. However, you may not find the defendant guilty of resisting arrest if the arrest was unlawful, even if the defendant knew or reasonably should have known that the officer was arresting him. If a peace officer uses unreasonable or excessive force while arresting or detaining a person, that person may lawfully use reasonable force to defend himself or herself. A person being arrested uses reasonable force when he or she does the following. 1. Uses that degree of force that he or she actually believes is reasonably necessary to protect himself or herself from the officer's use of unreasonable or excessive force. And 2. Uses no more force than a reasonable person in the same situation would believe is necessary for his or her protection. The defendant is charged in count 6 with willful and malicious harm of a peace officer dog, violation of Penal Code Section 600, Subdivision A. To prove the defendant is guilty of this crime, the people must prove the following elements. 1. The defendant struck, beat, or threw a dog. 2. The defendant acted willfully and maliciously and with no legal justification. Someone acts maliciously when he or she intentionally does a wrongful act, or when he acts with the unlawful intent to disturb, annoy, or injure an animal. 3. The dog was being used by a peace officer in the discharge or attempted discharge of his duty. Defendant is charged in count 7 with unlawfully taking or driving a vehicle, violation of Vehicle Code Section 10851, Subdivision A. To prove the defendant is guilty of this crime, the people must prove the following elements. 1. Defendant took or drove someone else's vehicle without the owner's consent. And 2, when the defendant did so, he intended to deprive the owner of possession or ownership of the vehicle for any period of time. Taking requires that the vehicle be moved for any distance no matter how small. A vehicle includes a passenger vehicle. The crimes and allegations charged in this case require proof of the union or joint operation of act of wrongful intent. Following crimes require general criminal intent: preventing a peace officer by the use of violence from performing his duties, charged in count 5, and striking a police dog is charged in count 6. For you to find a person guilty of these crimes, that person must not only commit the prohibited act, but must do so with a wrongful intent. A person acts with a wrongful intent when he or she intentionally does the prohibited act. However, it is not required that he or she intend to break the law. The act required is explained in the instruction for that crime. Following crimes and allegations require a specific intent or mental state: first-degree murder charged in counts 1, 2, and 3, and the lesser crime of second-degree murder in counts 1, 2, and 3. Use of a deadly or dangerous weapon charged in counts 1, 2, and 3. Evading arrest charged in count 4. Driving or taking a vehicle without the owner's consent charged in count 7. And the special circumstance of multiple murders in count 1, 2, and 3. For you to find a person guilty of these crimes, or to find the allegations true, that person must not only intentionally commit the prohibited act, but must do so with a specific intent and or mental state. Act and specific intent and or mental state are explained in the instructions for that crime or allegation. Each of the counts charged in this case is a separate crime. You must consider each count separately and return a separate verdict for each one. All right, ladies and gentlemen, that is the initial instructions in the case. I'll have some concluding instructions after the lawyers give their final arguments. Once again, remember that these arguments are not evidence. You only hear them but once. And if there are points that are raised that you wish to discuss later, you might want to jot them down. That said, first, you may